All right. Yeah, so thanks everyone for making the time to actually attend this workshop. It's going to be a really intriguing one. We have Jen and Mark from the Innovation Council here, and we will be learning a lot about IP from a global perspective. If you feel there's anyone in your networks who will benefit from this, feel free to share the link as well, and they can join in at any time. Yeah, so what we'll do is we'll start with an introduction from the Villgro side, and I'll give our CEO Wilfred a chance to, just tell you a little bit about what we do at Villgro and the impact that we are trying to make. But before Wilfred comes, I'll just request all of you to just where your name is to add your organization, so that whoever is coming in can really identify which organization you're working with. Yeah, so Wilfred, the floor is yours. Welcome.
Thanks, Edwin. Mine is gonna be brief. I'm assuming a lot of people already know about our work. So Wilfred is my name, co-founder and CEO at Villgro Africa. We are one of the oldest health-focused business incubators in East Africa. And this is our 8th year of supporting healthcare innovations, all the way from Ethiopia, Uganda, Rwanda, Tanzania, and now entering Ghana. And we give funding, we give seed funding. We are usually the first money in. So we write checks from anywhere between $20,000 all the way up to $100,000. Can either be in form of grants or equity or a combination of both. And what's unique about our model is we don't try to offer everything ourselves, right? And that's why we have this call today with Innovation Council. We like pulling in experts on areas and issues that we are not the subject matter experts ourselves. We call those technical assistance providers that we reach out to, and we either do an event format or we contract them if it's a long-term engagement, so that we focus on our core, which is business model development, and then everything else, including product development and other things that are not in our subject matter expertise. We like to work with partners like Innovation Council, and that's why we are here today. And mine is to just welcome you and encourage you to be very active audience and ask questions and make this interactive. And we're going to have a lot of fun in the next 1.5 hours. Thanks, Edwin, back to you.
Yeah, thanks. So I'm just going to hand it over to Jennifer to tell us a little bit about the Innovation Council and what they're about. Jen, over to you.
Great, thanks so much. And thank you so much to Villgro Africa for actually being a member of the Innovation Council. So the Innovation Council is an organization started in Geneva. We work with all kinds of different actors, public-private entities, SMEs, big companies, NGOs, industry groups, whatever. Everybody who's basically trying to commercialize a new solution to society's problems. So it's very broad membership, it's very diverse. And we do spend quite a lot of time working to advance innovation ecosystems that are inclusive, so that more people from emerging countries, more SMEs, more women especially, can use these tools. So this seminar today is organized in that spirit. And our goal is just to give you some basic information about IP, and then hopefully share some tools afterwards and some ideas as to where you can find further information and continue to engage with these topics and IP rights. And so I'm going to introduce now Mark Schultz, Professor Mark Schultz. He is a law professor at the University of Akron in the United States. He is also the director of the IP and Technology Law program at the University of Akron Law School. And he's somebody with a lot of experience on all types of IP issues and a very practical view on how companies, the kinds of considerations companies need to have in mind when seeking to use these tools. And so Mark is going to take us through a presentation. He's going to explain all of the IP rights that may be relevant for your businesses. And we'll make time for Q&A as we go through. So if you could put questions in the chat, that would be great. And then we can either call on you or we can answer the question as part of the discussion during the presentation. And after, we'll do like a moderated discussion and Q&A for some time. once the presentation is finished. So you'll have lots of time to ask questions. Okay, Mark, over to you to get started. Mark does have slides. Edwin, are you going to manage those? Can you put those?
No,
in?
I can share. I can share the screen and,
Do you want to do that?
and
Okay.
move them forward.
Perfect.
Yeah. Yes. Thank you. Thank you, everybody, for having me. It's an honor to be able to provide this training, and I look forward to discussion with you. As Jen said, I'm a professor at the University of Akron. I've taught intellectual property law for 20 years. I also practiced it for a decade before that, and I represented many startups and entrepreneurs, acting as their outside general counsel. So with that experience in mind, as well as my teaching, I'm going to tell you some things about intellectual property that I hope will be helpful to you. Let me share my screen. Let's see the IP overview. Right. So, okay. Right. Okay. So can you confirm that you see my screen, my slides?
Yep, very visible.
Okay, great. Okay, so today we're here to talk about intellectual property law. And so I've put up some learning objectives here, and it occurs to me to just state quickly why it's a relevant topic for you. I think you're probably aware of it to varying degrees, and some of you have had a variety of experiences with it. But intellectual property is a way to protect certain, to get exclusivity, to protect certain aspects of your business, and thus the investments you make in your business. It ultimately gives you a competitive advantage. And of course, it's not the most important competitive advantage for businesses. Having a great product comes first, having a great reputation, being first to market, having something that's difficult for others to duplicate. That's all important. But beyond that, usually, then businesses rely on intellectual property to protect some of the important aspects of their business. So we're going to talk about today, what the major types of intellectual property are. And I want you to be able, at least at the end, to distinguish what the differences are. What's the difference between a patent and a trademark and a trade secret? What are the basic requirements? What assets are usually protected, and why are they relevant to your business? So let's get started. We'll start with patents. So what's a patent? So a patent is something you get formally from the government. And there's even pictures here of these documents. They show that unlike most other IP rights, patents require an extensive interaction with the government. You apply to the government to get them, and they work with you to determine whether you're entitled to one. We'll talk about what patents protect. Now, here's a few examples. These are some old patent drawings. Patents protect products. That's a light bulb. They protect machines. That's the original telephone invention. They protect compositions of matter. What I mean by that are materials or new materials or chemicals. They protect methods. This was the original process for making aluminum. And so they protect new inventions of all sorts, and they give you the exclusive right to make, use, and sell those things, which means they give you the right to protect from others doing that. Now, there are several key requirements to patentability. And the biggest one, I think, is understanding that you have to have something that's truly new. It has to both be new in the world. Could everyone turn off their microphones, please? Mute yourself. I think we're getting some interference in the background. So inventions have to be new. You have to be the first one to have done something. And it also has to be, though, that's the second requirement on the screen, is it has to be something that's not obvious, right? Like, you can be the first to do something, but if it was the obvious something, an example I've used before, for example, say you invented a new medicine, but and you were the first to make it, but the medicine was very bitter and difficult to swallow. And so you have the idea, well, what if we put sugar or some sweetener in the medicine to make it easier to swallow? Now that would be new, right? Because you also invented the medicine. You were the first to invent the medicine. Now you're the first to combine it with sugar, but it's a very obvious thing to do, right? It's not, you haven't really contributed something truly new to the world, because we all understand that bitter things are made, easier to swallow when they're made sweet. So, you have to actually have contributed something truly new. But if you have something new, it might be patentable. It has to be also, the third requirement, capable of industrial application, useful. It can't just be, say, ornamental or not do anything. It has to actually, perform some useful task, be capable of industrial application. Now, as I said, you have to apply for a patent, right? So the fourth requirement is they have to be fully disclosed. You have to reveal to the world how to make your invention. That's kind of like the deal underlying patents. The bargain with society is the inventor reveals everything about the invention. The patent is essentially, in theory, should be instructions on how to duplicate the invention, and in return, the inventor gets 20 years of protection. But meanwhile, other people can study the teachings in the patent and learn from it. And when your 20 years is done, in theory, they'll be able to use the patent to copy the invention. So you get strong protection for 20 years, but you got to tell everyone how to make the invention. And the last thing is the kind of subject matter allowed by patent law. Different countries exclude certain things from patentability, and that's probably at the level we're talking about. The kind of patents you might be interested in are probably not likely to be subject to subject matter problems. Okay, so just summarizing them, the invention has to be new, inventive step, capable of industrial application, has to be fully disclosed, and has to be patentable subject matter. So those are the technical requirements for patentability. Now, how do you enforce a patent? You have to go to court to do it, right? So when you have a patent, you can enforce it by going to court. And that means you can stop other people from making, using, or selling the infringing products. So essentially, you can use the patent to stop people from competing with you using the same invention. You can also, if you've incurred damages or they've made profits, you can recover those. Now, this is private enforcement. We don't have criminal enforcement of patents, so it's up to the patent owner to enforce their patents, which can be expensive. Moreover, getting a patent is not automatic, right? It requires an application to the government. So in Kenya, it's the KIPI you would go to. The application is reviewed by a patent examiner, and the patent, it's usually an extensive review. It usually requires some revision. So there's a back and forth with the patent examiner. Drafting a patent, is a very technical exercise. And getting the patent is not the end of the story. There is more that's going to happen. You don't have final security because the validity of the patent can be challenged. Some countries have administrative procedures that allow people to file a challenge and say that patent shouldn't have been granted. Then you must go to court to enforce your patent if somebody infringes. And that it's almost that during that infringement lawsuit, it's a very common, in fact, it's almost automatic that the defendant will challenge the validity of the patent and say it should never have been granted. It doesn't meet those. There's something about it that doesn't meet the requirements I've described. That's something anyone could do in a patent lawsuit. So I think it just goes to show you that getting a patent is an extensive process, and then it never, it's never safe. It never really ends. You have to enforce it and defend it, and it will be attacked. Another thing important to understand is that patents, and really every other kind of IP we'll talk about today, but particularly, patents, they're territorial. There's no global patents. So each country decides whether to grant the patent. That means you have to apply in each country separately to get a patent. If you have a patent in Kenya, that means your invention's protected in Kenya, but it doesn't mean it's protected anywhere else. You would have to apply, in say Europe, to the European Patent Office to have it protected in Europe, the US Patent Trademark Office to have it protected in the US, and so on. Now there is regional cooperation. For example, ARIPO, one of the African IP organizations that allow you to get patent protection in more than one country at once. There's cooperation between countries in these organizations. And there is a way to file in multiple countries at once. It's a simple, I guess, it's an efficient procedure that you file your patent using the Patent Cooperation Treaty, the PCT, but you're still going to have to meet the requirements of each country, pay their fees. Your lawyers are going to have to talk to the patent office in each country and satisfy them that the patent should be granted. So, when one chooses to patent, one has to keep that in mind, that in an increasingly global marketplace, that your patent, that you often are going to want to get a patent in more than one place if you want to get a patent. Okay, let's talk a little bit more about your business. Why might patents be relevant for your business? Well, I think for some of you, you may be making products for which you might invent a novel manufacturing process, in which case you might want to protect it with a patent. Medical devices are often protected with patents because they're essentially, they're new machines in patent terminology. They're a new type of machine that you might want to protect. If you're doing something, say, in consumer electronics, similarly, you might want to protect that. There's an example here of a device that's an attachment to a smartphone that I know was invented and deployed in Kenya to do remote eye examinations. So that's an example of something where patent protection is important, particularly because it was a really novel device and it was a great advance. And I know the entrepreneurs wanted to build a market elsewhere. So they looked to, they made sure that they had patents overseas. Now, some practical tips though. I think when it comes to patents, you have to ask whether patents are practical for you at this time in the life of your business. They're expensive to obtain because you have to pay fees to file them. And more importantly, it's really not a process you can do yourself or do yourself with a little bit of help. It takes expertise to draft a patent properly that can meet all the challenges that would inevitably come if you try to enforce the patent, which brings me to the second point. Patents are even more expensive to enforce. And the other thing to consider is just where you want to patent. You don't have to patent in every country in the world, but you may, if you have something like a really novel device or something that you can't protect otherwise, you may want to consider particular patents in particular large markets where either companies that might copy you are located, and or where you're most likely to find your largest market. I'll pause there because that's what I had to say about patents, and I know Jen had some questions or thoughts she might add.
Yeah, I mostly wanted to ask some questions, for example, about designs. So you mentioned that patents are really only for things, in terms of their performance, their novelty, et cetera. Is there a patent for designs? Can you talk about what that might look like?
Oh, sure. So I've been talking about utility patents, which are for new inventions, for devices and methods of manufacturing and the like. There is a separate category called a design patent, and those are for new designs. And the challenge there, of course, is proving that you have it. What do I mean by design? I mean the configuration, the aesthetic configuration of a product. So for example, you know, in the smartphone world, Apple is a company that pays a lot of attention to design, to making its products look good, and you know, that kind of creates a good feeling in consumers. So they have patented, they do have some design patents, like the rounded edges of their phones. You know, they did a design patent on essentially the rounded edges. Now, the question is going to be, though, in those cases, whether that's truly a unique aesthetic contribution, et cetera. And it's a fairly, I'd say design patents can be useful, but they kind of have limited protection in a way, because you know, we all know that there are a lot of phones out there, and there are a lot of different ways to implement this design. And there's pretty good argument that the reason, you know, you round the edges is so that they don't hurt you when you put it in your pocket. And so, you know, the Apple doesn't really, when it gets design patent on rounded edges, it's probably a very limited one on edges that are rounded, that look are rounded in exactly the way they've rounded them. And lots of other companies have, you know, can get around that design patent by just making their product look a little different.
I also had another question for you, Mark. Looking at, for example, this slide here, are patents practical for you? Can there be situations where, even though they're expensive, a patent is really something you should consider? Like, is there a specific field of technology or type of invention where it's really going to be wise to look into that right from the start?
I think so. A couple things. One, I think one of the major criteria when we talk about trade secrets, we'll think about this a little. If your invention is easy to copy and really reveals itself once you start selling it on the market, you're going to at least have to think about that, right? If you know, have a clever new gadget of any type that people can pick up, if your competitors who understand the technology can pick it up, look at it and say, aha, I know that was very clever, but now I know how to, you know, how to do that myself. That is, you know, you're very much in danger of being copied in those instances. And some of the fields where that can be particular, and another issue is if it takes a lot of money, if it takes a lot of investment to bring your product to market, and then it's easy to copy, then you're in a really kind of a terrible spot, right? Because you spend a lot of money developing the product, bringing it to market, and then your competitors can immediately skip all of those expensive steps and start copying it. Patent protection is really important. And so, for example, with respect to one of the classic examples are pharmaceuticals, which probably are not as relevant to small companies. Although if you're in the biotech space and developing a pharmaceutical, you do need to think about this. But you know, also medical devices are sometimes like that. Anything where you have to invest a lot of money in testing and making it work, and maybe even regulatory approval. And then you've created this device, and your competitors can immediately look at it and figure out how to duplicate it. Then you got to think about patent protection, because unless it's really hard. You know, it's really hard to keep people from copying it, and they're always going to be in a better position than you because they didn't have to spend all the money to get to that same place.
Thanks. Maybe continue with some of the other IP rights, and then we can open it up in a little bit for questions after the next type.
Okay. All right. Yes, let's go. Trademarks. So trademarks, I mean, simply put, are brands. They're a word, a logo, a symbol, or a shape that identifies the source of a product. So a single source of a product, right? I mean, one of probably the world's most famous trademark is Coca-Cola. And so when you see a can with the Coca-Cola trademark, that logo, that red with the stripe there, you know what that product is. You don't think, it's not like if you go to the store to say buy sugar, when you see something labeled sugar, it could be produced by just about anyone, right? But when you see something labeled Coca-Cola, you know that comes from a particular company, and it's a particular product with a particular taste and particular qualities. And that's what trademarks stand for. It's like they guarantee you that you're getting what you paid for, that it's a particular source of a product by a particular manufacturer. And what kinds of things can serve this purpose? What kinds of things can be trademarks? Well, really anything capable of conveying meaning to people that you can use to distinguish the goods of one business from another. Not all countries recognize everything, but the simplest thing, the thing we all think of as a trademark, are the word marks, right? I used the example of Coca-Cola, Safaricom. There are many famous brands, Apple. Those are names, but also logos, right? The previous slide, shows logos. That's the particular design mark. When you see that kind of font, you recognize that sometimes. And then sometimes more in more complicated ways, maybe the product appearance, maybe a particular color or a particular configuration of the product. Although that is more challenging because usually consumers, you have to sell the product enough and work hard enough to associate that, say, color or appearance with the product, such that customers, when they see it, begin to understand. When you go to the grocery and you see that particular products have packaging, say it has a red package or a green package. As a consumer, when we look at that, generally we just think, oh, that's red or green. They chose that color because they like that color, perhaps. But sometimes a company kind of teaches you to say, oh, that's that company's color. The Dutch bank ING has taught us that orange is associated with them. The phone company Deutsche Telekom has taught us that pink is associated with them. So sometimes you can convince, you can kind of do enough advertising to teach consumers to expect that these colors are associated with the product. But anyway, mostly I think from your point of view, you're going to be interested in particular word marks or logos. And why does it matter to your business? Well, every business needs a trademark. Every business needs customers to know who they are and to associate their products, with an exclusive, source. You want them to keep coming back to you. And the way they find you is because they know your trademark, right? If you covet a phone from Apple, or your favorite, soft drink is Coca-Cola, the way you find that is through the trademark. That's the way you go back and buy it again and again. And so that is important. And it's also important for you to make sure that you choose one that you can protect and won't have to change because it's too similar to someone else's. So these are some of the requirements for trademarks. When I say choose one you can protect, choose one that meets the requirements for trademark protectability. So first and most important is avoiding choosing a brand that's the same or confusingly similar to a competing product. If you're starting a phone company, you probably don't want to use the word Apple in your name. It's too similar, right? Or I remember once a more real life example was my firm represented a company, a software company named Intelisys. And we were shocked to discover they were getting a big round of venture capital financing. And we were shocked to discover they had never cleared their trademark. They had never registered their trademark with the US Trademark Office or any other trademark office. And so the venture capitalist said, well, before we invest money, you need to make sure that your name is trademarked, properly registered as a trademark. And of course, what the trademark lawyers at our law firm discovered quickly was that Intel, the technology company Intel, opposes the registration of any trademark in the technology field that has the word Intel in it. So Intellisys was going to be a problem. Our client had to change their name. They had to tell all their customers to get, that they had changed their name. And of course, the venture capital investors, as venture capital investors tend to do, said, okay, well, that means we need to either give you less money for the same amount of percentage of ownership in your company, or we need a bigger percentage because your company is less valuable, because you're going to have to spend money to rebrand and inform all your customers of your new name. You need to use the trademark in association with selling a good or service. You need to use it, right? You need to actually label your products or services with it. You need to make sure it appears prominently. You need to register it with the Kenya Industrial Property Institute. And when applications are examined by the government, in the case of Kenya by the KIPI, they're examined, but much less stringently. This is a process that many business people, once they have a little bit of experience, may be able to navigate themselves, may be able to navigate with some free legal help, and maybe just spending a relatively small amount of money to get your trademark registered. And it's worthwhile because, of course, you want to make sure you have a good trademark, that it's registered and protected. And when the government examines trademarks, it's a much more simple process. For example, the trademark examiner in my example of Intellisys would have probably done they would have done a search of registered trademarks, and the trademark examiner would have come back and said, well, your proposed trademark is a lot like Intel. So that's the sort of thing that you would hear as an objection. But it's obviously different from a patent where they're examining all the prior inventions. Your patent document is very long and they're examining that. The trademark is a pretty simple proposition. What's the name and what goods or services are you applying it on? How do you enforce trademarks? It's a little different from patents. Enforcing trademarks, it's first and foremost, I think businesses try to would enforce trademarks on their own behalf. And the way you enforce a trademark, the cause of action, the reason you give to a court, is that somebody else's use of the same trademark or a similar trademark is going to confuse consumers as to the source of the goods or services, right? So if I start making a soft drink that has, a red label that looks very much like Coca-Cola, that's the sort of thing Coke might object to. Even if I use a different name, but the can looks very, very similar to Coke, what could happen? Well, we aren't always careful when we reach into the beverage cooler to choose a drink. We might grab the wrong can because we see the red one that looks like Coke, and we'll be confused. We'll buy the wrong beverage. And so that's the sort of thing you're asking a court to stop from happening. And when you go to court, there's two different things you're really asking the court to do. First and foremost, you're asking them to stop the competitor from using the confusingly similar trademark. And a lot of times what you hope to do is stop it so soon that there really aren't any damages to collect. You really just don't want somebody out there confusing the marketplace using a similar trademark or the same trademark. But if there have been damages, you can also ask a court to require them to compensate you. Now, unlike patents, there is criminal enforcement of trademarks. The police will get involved when it's a case of counterfeiting. So counterfeiting is intentionally producing fake goods, right? It's a little bit different, right? Because sometimes competitors make choices, like the Intellisys story I told you, right? They didn't want to confuse people or be close to Intel. They just thought that they had chosen a good name that sort of sounded like intelligent. They liked that name. So there was no bad intent there, and it wasn't a fake Intel product. So that's different. That's a little different from counterfeiting, which is when I actually am purposefully trying to deceive people, if I haven't just used Coca-Cola Red, I have made fake Coca-Cola in my bathtub and have put it in a, refilled a Coke bottle and I'm trying to sell it. Now I'm committing a crime, and this is when you can ask the police to get involved and help you. And that's, I think, in developing economies and emerging economies where you have a lot of informal markets and large marketplaces, counterfeiting can be a particular problem. And in the last 20 years or so, what we've seen, and I'm sure you can tell me awful stories about it, is some of this is no longer just a local operation. Some of it originates in factories in China, but lands in markets. I've seen this in the markets of Africa, where an African entrepreneur has a new product or new craft design, and a few months later, there are cheap Chinese versions of it being sold in local marketplaces in Africa. It's a very frustrating phenomenon, and this is the kind of large-scale commercial criminal competition that you hope you can get the police involved in, which how effective the police are at battling counterfeiting varies by country, it varies by city. So it's just a matter of determining whether your local authorities are particularly helpful with counterfeiting or not. Okay, practical tips. A few things about choosing a trademark. So I said, first of all, don't choose something that's confusingly similar to a competitor, but it goes a little beyond that, right? Made up names are stronger. All right, the easier it is for consumers to understand when they look at your product that, oh yeah, this is a trademark, then they're more likely to, it's more likely to function strongly. So, there are many made up names, like for example, in America, there's the oil company Exxon. And, when you look at Exxon, we English speakers look at Exxon and we don't think, there is no such thing as an Exxon, right? When you see that, you immediately think, if you've never seen Exxon before, you still look at it and you think, oh, that must be a brand, right? But on the other hand, generic terms can't be trademarks. So, butter, milk, that those can never be trademarks. So, that's kind of the spectrum, right? The strongest ones are the made up words. The weakest ones, the things that can never be trademarks, are those generic names for products. And in between, there are other things. So descriptive names can be a problem, right? What do I mean by a descriptive name? Well, you've come up with a brand new product and you would kind of like to tell consumers what it does or what it is. So, marketers often like to choose descriptive names for brand new inventions. So one that I can think of, for example, is the skates called roller blades, right? The inline skates that are like a blade that somebody invented back 30, 40 years ago. They called them roller blades. And, that's a tough name because it does sound descriptive. It tells, what's a descriptive name? It immediately conveys information about the product. So, if you were selling potato crisps and you wanted to call them tasty potato crisps or crunchy potato crisps, that's a descriptive name. And so descriptive names can function as trademarks, but remember how I said sometimes you have to convince consumers they're supposed to be a trademark. So sometimes you're going to have to sell the product for a while. You're going to have to sell enough of it. You're going to have to do enough advertising that you convey the message that this is a brand name, not just a description of the product. Besides made up names, sometimes real terms that are not associated with the product are useful as trademarks. What do I mean by that? Well, let's go back to the phone, right? The Apple phone. I mean, Apple sells phones, they sell computers. Apples don't have anything to do with electronic goods, right? So when you walk into, say, an electronics market, and if you'd never heard of Apple computers, but you see the name Apple above a computer, you don't think, oh, did this electronics market start selling, fruits. No, you know that, oh, okay, when I see the word Apple by a computer, they must be branding. They must have chosen that as a brand name, because apples have nothing to do otherwise with computers. So those kind of trademarks can be really effective, because when consumers see them, they immediately think, oh, that must be a trademark. Apple computers, other names that have nothing to do with the product are quite useful as trademarks. One last point about trademarks is you have to protect them. Use it or lose it, I said. If you let infringing competitors go unchallenged, your brand loses its ability to distinguish your product, right? If Coca-Cola just gave up tomorrow and stopped enforcing its trademarks, and every time you went to a store and went to buy a beverage and you found 100 different kinds of drinks named Coca-Cola, and you never knew which one was which or who made which one or what it would taste like, you would stop thinking that Coca-Cola was a particular brand of soft drink, and it would just be a word that people put on drinks. So you never want to be in that position as a brand owner, which unfortunately in some ways, lawyers kind of like this, because it means you actually do have to defend your trademark. You can't just ignore people using your trademark. Unlike other types of intellectual property, there's all sorts of things like, say, copyrights we'll talk about shortly, where people don't mind, like the author J.K. Rowling, who wrote the Harry Potter series. She lets people write fan fiction stories and post them on the internet. There are actually millions of these stories. She's never going to lose Harry Potter just because she lets a fan write a Harry Potter story. That's not how copyrights work. But if Coca-Cola lets everybody who wants to make beverages named Coca-Cola, Coca-Cola will no longer function as a trademark. Jen, do you have any questions or comments?
Yeah, I do actually. What you've been talking about is kind of the IP management, which I find really interesting. So the one question is getting the IP right, securing it, deciding whether it's strategic to undergo that process. And then the second one is, how do you use it, right? So what are some of the considerations for actually using that tool in a practical way to grow your business, to protect your market, and to not get in the way of what other people are doing or infringe on their rights. So I think that's maybe something we'll talk about more at the end. But for now, why don't we continue and go into the next IP right?
Okay, very good. All right. So next, let's talk about trade secrets. So what are trade secrets? Well, the name is sort of right there on the name on the label tells you a lot about what it is. So the word trade, right? It's information that has commercial value to your business that gives you an advantage from keeping it secret. And the information has to actually be secret, not known by people outside the business, and not easy to uncover. Some, like I mentioned, some inventions, some products, you sell them, and anyone who's clever enough or understands how these products work can pull them apart and figure out how it works. It's not a secret. You also have to take reasonable measures to protect secrecy. And the way I explain this is courts won't do what you haven't bothered to try to do yourself. So, if you leave your secrets out lying around where anyone can see them, you're unlikely to be protected. And how long do trade secrets last? Well, they could last forever in theory. Now, we all know in real life, most secrets are hard to keep. They don't last forever, but in theory, they can last a long time. To go back to Coca-Cola, an example people like to use sometimes of a trade secret is the recipe for Coca-Cola. Now, I'm not sure that that's the world's biggest secret, because you can pretty much guess, if you're an experienced beverage maker, how to make something that tastes like Coke. But still, they have a secret formula they keep in a big vault in Atlanta, Georgia, United States. And if you ever tour Coca-Cola, they put on a bit of a show. They have a giant locked vault. You walk by and they say, that's where we keep the recipe. But that's been a secret of theirs for over 100 years. So it's an example. Trade secrets can last a long time. On the other hand, they might not last that long because you're, sometimes, you might figure something out just a few months ahead of everyone else, and then they catch up, right? So some secrets don't last very long because everyone else is trying to figure out how to do the same thing. What are they protected against? They're protected against taking by improper means, which means most likely like a breach of duty by an employee. An employee starts their own business using the secrets, or they sell them or give them to a new employer. Also bad acts, though. Somebody breaks into your building, they trespass, they hack into your computer system. That is also an improper means of obtaining a trade secret. Now, by implication, there are actually proper means for getting trade secrets. Trade secrets only protect the work you've done for yourself to create your new thing, your new invention or business information. If somebody else, other people can independently create it. This is different from patents. Like patents protect you from everybody else who comes along and tries to invent the same thing. But with trade secrets, people are allowed to do their own work. They just can't steal your work. So you're only protected from people taking your information. Other people can develop their own information doing their own work. What do trade secrets protect? Well, I'm not going to read this whole slide, but there are a lot of things listed here to give you the sense that they protect a wide variety of things. They protect technical information like know-how and manufacturing techniques. They protect business information, which is probably very different from, say, what patents protect, because they might protect your customer list or your supplier list, only if those things are really secret, but sometimes they are. Sometimes you might have a large network of suppliers and you have a secret, you have what you pay them and where you get your products and your product requirements. Those might all be confidential, and if you sufficiently protect them, they can stay a trade secret. Trade secrets even protect trade secrets might protect the beneficial things you do, like you have a new method of doing business, a new manufacturing method, but they also sometimes protect what we call negative know-how. So if you spend 5 years trying to, say, perfect a new type of paint, for example, you're looking for a new formula for paint that dries faster, and you try 99 things that don't work, and the 100th one works. Well, those 99 failures are actually a really important trade secret, because if an employee leaves and goes to your competitor, and your competitor's working to make fast drying paint too, and that employee says, no, don't do these 99 things. Don't do these 99 failed things. They've just saved 5 years of work, right? So you can see trade secrets protect a wide variety of information. In fact, they really are the type of business, the type of IP on which businesses rely most. There have been a number of surveys around the world, and we get these kind of results. They see 75% of companies view trade secrets as strategically important. Most of them rank trade secrets among their most important competitive advantages. So it's something to give thought to. And what trade secrets might be important to your business, to entrepreneurs. Well, sometimes it's your know-how, like you've worked hard to figure out how to do something. You might have a manufacturing process. You might have perfected the fastest, cheapest way to do something. That know-how can be very valuable. I mentioned supply chain information before, your customer lists. Also today, algorithms are increasingly important trade secrets, and maybe your database as a whole, if you've assembled a database. So all these things can be trade secrets if you protect them properly. We wanted to talk a little bit about the difference between trade secrets and patents, because they overlap, and this can be a point of confusion. So sometimes you have a choice to do either trade secret or patent protection, but trade secrets they only overlap. They're not just the same kind information as patents, because trade secrets can potentially protect all valuable information, like your customer list. And patents only protect truly new products or processes capable of being made or used in an industry. So, for example, your customer list can never be patented, but it can be protected by trade secrets. And some information can be, say you have a new manufacturing process, that might be patentable. And it's probably something you could keep secret if you sufficiently protect your factory floor, you make sure your employees understand it can't be talked about, et cetera. But then there are things that are patentable that can't be protected with secrecy. As I've mentioned before, sometimes some inventions inevitably, once they're released into the world, once they're sold on the market, people can look at them and learn from them by looking at them how to do them. So they're not a secret. So patents would be the only way to protect those self-revealing inventions. Just like the other things we've talked about, you can either use the law to stop people from using the trade secret and get damages. Usually with trade secrets, your hope is that you can get protection. You can stop them from using the trade secret quickly, because sometimes once somebody else starts using your trade secret, the knowledge might spread and it might stop being a secret. So practical tips with trade secrets, I think, as I mentioned, they're really important to small businesses. And so you probably have at least some information you're going to want to protect with trade secrecy. And so one of the most important things to understand is most trade secret breaches come from your employees. So you have them. There are things called non-disclosure agreements. They're often quite familiar to entrepreneurs, so maybe you've even used them or signed one. And those are really important to have your employees sign, but they also need to understand what they're signing, right? Like sometimes when you start a job, you sign a lot of forms and you don't remember what they're for. Trade secret, when you get an employee to sign a non-disclosure agreement, they should actually understand what they're obligated not to disclose. You have to tell them what the secrets are. You have to train them for both the practical reason that you don't want them to breach trade secrecy. You don't want them to reveal your secrets to customers or to just people they know in the industry. And you also want them to know that that they're not supposed to take them to their new job if they quit your company. But to do that, you have to identify the trade secrets and tell them about their obligations. And particularly when somebody leaves the company, it's important to sit down with them and explain, okay, while you worked here, you learned X, Y, and Z. You cannot use X, Y, and Z in your new job. You cannot tell your new employer about these things. These are our trade secrets and you need to keep them. And also, besides dealing properly with employees, you need to take measures to protect your secrets. Remember, I said the courts won't do for you what you didn't do for yourself. And the more important the secret, the greater the protection required. What do I mean by that? Well, imagine you had a revolutionary form of clean energy. You had invented new fusion energy or something. What would that be worth? Trillions of dollars, maybe, if it were really truly revolutionary. There's probably, you probably should have the kind of protection. You should have armed guards. You should have, the kind of things you see in a science fiction movie, retina scans and all sorts of, protections of access. What about, say, you have a small service company and you have a customer list? Well, obviously, that's not the same kind of value. You're not required to have armed guards, et cetera. It wouldn't be worth it. But you should have password protection on your computers. Your employees should not be able to print the list and leave it laying around in the front lobby, public lobby of your office space. So but what the law asks of you is that you take some kind of reasonable measures to protect your trade secrets. And that means, I think, in the practical way that you're thinking about it when you're dealing with third parties like business people, particularly contractors, independent contractors. A lot of you probably work with independent contractors. Those people, you need to make sure you either don't share secrets with them, don't give them access to systems, or if they do have access to your systems or facilities where there are secrets, they need to sign NDAs and they need to understand what their responsibilities are. And even things like, excuse me, even things like waste disposal, you have to consider. There are a number of trade secret cases where somebody, dumps paper, files with trade secrets in them in the garbage, and a competitor comes along and pulls them out of the garbage. Or even one case where somebody got the bright idea, some big corporation got the bright idea that they could recoup a little money by recycling paper, by selling like paper for recycling, which happened to contain all their trade secrets, and their competitor was their biggest recycling customer. They were buying all the paper that the company was recycling and finding out all their secrets. So these are the kind of practical things you need to think about just basic security to make sure you're not giving away your secrets. Jen, any questions or comments before we do the last bit here?
No, but I love these stories about the lengths people will go to get secrets, like flying over to see the factory, how it's been built, etc. But let's not lose copyright, because our time is, I want to leave time.
This was, we had an hour. So the last 5 minutes we'll do copyright. So copyright protects original expression. For example, written expression, images, or video. Now, we most think about copyright in the context of the creative industries, the movies, music, and that's probably not what you all are doing, but copyright can protect things like website content, software code. That may be important to many of you. Even like the product appearance, your product label. So all of these things can be protected. And it's also important to remember in this context, sometimes it's not just what you're protecting, but what's protected by others. So if you're putting together a website, you probably shouldn't be, you shouldn't be just taking pictures that you find on the internet and putting them on your website, because you could get sued by a photographer who owns the copyright in the picture. So keep that kind of thing in mind too. So all of these things are protected potentially by copyright because they're original expressions. Software code is a bit of a strange case, but the way most courts and countries have decided to protect it is they think of it as, people write software code. And yes, a lot of software code is very functional and it's the same code that any programmer would use, but maybe as a whole, the software, the entire set of the entire set of source code as written by a programmer, probably represents a copyrightable work that's protectable, and it's protected from copying and piracy. What are the requirements for copyright? Well, it has to be original, not new. It's a little different from patent law. It just has to originate from the author. It has to be your own work, right? So think about any popular movies or music. Like we, as people who enjoy culture, we know that most things we enjoy are very similar to other things. They're not new. Action movies are a lot like other action movies. Love stories are kind of the same plot over and over again. They're not truly new, but the important thing is they're original, which means they're not copied from somebody else. And they're things that don't already exist out in the world, like facts. So if I'm a historian and I, write a biography of somebody, and I, do my research and I collect facts about them, their birthday, where they lived, who their family was, those are all facts, right? Just just because I write them down or even that I researched them, I didn't create them. They didn't originate from me. They were already out there in the world. So I can't own that, but I can own my own way of expressing myself, right? So people can't copy my book, but they can use the facts out of my book. My copyright just protects my own expression, the way I express myself. An important thing to understand with copyright is no registration is required. The other thing I think is particularly important for entrepreneurs to know is that the author is the owner. So what? Okay, that's interesting. Well, the author is the owner. That means that if you hire an independent contractor to design your website or to do some other graphic design work for you, maybe make a logo for your business, they will own the copyright unless you have an agreement that says otherwise, because they're the author. And so this has happened to clients of mine. It also happens like they hired independent contractors to write software code. If you don't get an agreement with those people, they own the copyright, which means maybe you have, because you paid them, you have the right to use it, but you may not have the right to resell it. You may not have the right to alter it. So when you work with independent contractors who do creative work or programming for you, it's really important to get something in writing that assigns the ownership of the copyright to you in their work. So as I've been saying, why might copyright be relevant to your business? Because you might have software code, a website design, product packaging, you might hire contractors, and you may want to use images and designs you get from others. So you got to keep this in mind, that the world is filled with creative expressions, and you want to make sure the ones that are important to your business, that you own them and that you haven't taken them from others. So my practical tips, as I've noted, be careful dealing with contractors, and be careful where you obtain images and text. And that leaves me to the very end here, summing it all up. So there's going to be some handouts that have charts that summarize the different types of different types of IP. And I think that, Jen, I think I'll end there rather than do the review problems, because I want to leave time for questions. Does that make sense to you, Jen?
Yeah, that makes good sense to me. Hopefully people have some questions for you. I'm looking at the chat and I'm not seeing any coming in for now. Don't be shy. But if we don't have any questions, we could do the review problem, or I could also ask Allison Mages from WIPO if she's joined. I'm just looking. If she wants to present some of the tools that the World Intellectual Property Organization is preparing for SMEs.
I see.
Program.
Yeah, I do see Allison here. So let's, I'll hand it over.
Hi, good afternoon, everyone. Sorry, I was having an audio problem there for a moment, so my apologies. Jen, will I have permission to share my screen?
Sure, we can arrange that.
It looks like I do already. So I'll just let me make a quick introduction, and then I'm so happy if I can answer any questions. So Jen, thanks very much for the invitation. My name is Allison Mages. I'm the head of the IP commercialization section at WIPO in our IP for Business division. And basically our role is to help businesses maximize the value of their business through intellectual property. So that's what we do. With that, we have a number of tools available that I'm going to share the screen right now that I understand are relevant to what you have been discussing today. So I'll just ask if Jen or Mark could let me know when my screen is visible. Awesome. I think I see a thumbs up.
It's
Mark,
visible.
Great.
Yeah.
So I'll mention a couple of different tools and one that's coming out very soon. The first are a series of IP for business guides. The QR codes are here, and I'll make sure that, Jen, that you have the materials so that it can be sent out afterwards. These are a series of guides for different IP rights that you've heard about today that go
Uh-oh.
Is anyone
Is
else
that me?
having? No, I think
Yeah.
Allison is frozen for a second. Let's let her, let's see. Maybe we'll let her dial back in.
Yeah,
If she's
I
frozen,
think
she'll
we have
figure
a-
it out. She'll come back. We do have a question mark in the chat. Do I still need to register my product as copyrighted if I've already patented it? Good question. Why don't you take that
Okay.
for Allison to come
Sure.
back?
Sure. So patents are, I hope Allison knows she's frozen and isn't just,
I'm going to text her right now. Yeah.
Yeah. So, the patents and copyrights are different. A patent protects, so each of these IP rights protect a different aspect of your intellectual assets, your intangible assets. And so really the law tries to be careful that they don't double protect the same aspect of your product. So, if I've patented my invention, that's one type of protection. And that's what patents are for, the inventive part of what I've got. Then I decide to give it a brand name. Well, that's what the trademark protects, right? And that's different, right, from the product. And then say I've decided to put up an informative website with instructional videos about how to use my product, and graphics and graphic design on this great website. Well, that's going to be protected by copyright because that's expressive, right? It's not an invention, it's not a brand, it's an expressive work. It's a little bit of a small movie, and video / movie, and it's graphic design. And then maybe I've realized that my product, I've developed the most efficient way to get the supplies I need for my product. I have all these great exclusive supply arrangements with different suppliers. I've got a global supply chain, and maybe I've decided to I keep that a secret, right? And that's because that's an advantage for me to keep that secret, so my competitors can't duplicate my efficient supply chain. That's a trade secret. So all these things are a little bit different, right? And so when you've patented your invention, you're still going to have other things about your product that you might still want to use. Other types of IP rights that you might want to use to protect different aspects of your business. So we really don't think in terms of patenting a product. Like the invention is not the product itself. It's what is new, useful, and not obvious about the product. It's sort of like, what is the extra thing that's special about your product? Like, look, there are lots of phones, right? We all have different brands of phones. There are Apple phones, Huawei phones, many different brands of phones. And most of those phone manufacturers, they have something a little special about their phone. Apple's proud of its cameras, and different companies, they might have different features about their screens or their buttons, and they'll patent those particular novel inventions. But that's not the product itself, right? The product is a phone. And many people will have the same product, but they're going to invent something special. And so the patent's only going to cover that little increment, that little special new novel feature that they own exclusively. So that's, I think, one thing to consider is really you're protecting different aspects of your business with different IP rights.
Okay, thanks for that answer, Mark. I think Allison is trying to get in. Edwin, if you can admit her. She had an issue with her computer. So we can get her in.
So Edwin had a question about if I file some IP right for my product locally, can a competing product that has filed its IP in a different country still sell in my geographic region? Not if they violate your IP rights. So it can be a challenge. Like, for example, trademarks sometimes are identical brands can be used by two different companies in two different countries. So, when I had clients that wanted to sell globally, we would often have to clear their brand in many different countries. On the other hand, we had a client, Anheuser-Busch, that makes the product. They're owned by InBev now, but they make the beers that are popular in America. One of them is Budweiser. Well, Budweiser is also a brand owned by a Czech brewery, and so in some countries, if you buy a Budweiser beer, it comes from the Czech brewery, and it's actually a much better beer. In some countries, it's the American Budweiser. They're two different companies, each with their own trademark, and they're each going to have exclusive rights in each country that they have got to first and established their rights in. So yeah, like if Budweiser tried to sell, if the American brewery Budweiser tried to sell its beer in Czechia, in the Czech Republic, the Czech company could stop them because they own the trademark Budweiser in that country. So yeah, that's, I think, you have your territorial rights in each country where you filed them, where you've protected them, but you're going to, other people are going to be able often to, have their own rights. Now, if it's the one thing I'll note about patents is really only one company, only one inventor can get a patent on a particular invention, most likely, because once somebody else files a patent or uses the invention publicly, nobody else can patent it, right? When I say patents have to be new, when we say new, it's new to the world, but also hasn't been patented or used before anywhere else. So you're not going to have, say, a patented invention in Kenya and somebody else is going to patent the same thing in Tanzania and then be competing with you because one of you shouldn't have got a patent, right? Whoever, if there was already a patent somewhere else, then you can't get a patent on it. So, but for the most part, when we're thinking about, say, trademarks, I think trademarks are the thing you need to think about. Like, if you're an entrepreneur in Kenya, but you are planning on selling across the border, in neighboring East African countries, then you're going to want to think about whether you can protect your trademark in those countries, choose a brand that you can protect in those neighboring countries, and make sure you protect your rights in those neighboring countries. And so I see Allison. So
we've got Allison back. So let's give Allison a couple of minutes, and then we'll go back to some of these questions that are in the chat. Allison, over to you.
Great. And so sorry, everyone, that my technology failed me today. Jen, I'm not sure where we left off, where I seem to have lost the connection. Do you want me to, do you remember what the last thing you heard was?
Yeah, I was going to say, why don't you put your slide up and go quickly through some of the most relevant programs for these SMEs, primarily in the health and IT sectors.
Great, excellent. I'm going to actually just do it like this and send you a slide afterwards because I managed to join on my mobile. So my apologies, everyone. So again, we have a number of different tools at WIPO to support businesses. The first are a series of IP for business guides. These are specific to individual IP rights that you've heard about today. All of them are downloadable on our website, very easy to use in business language that will walk you through the process of securing the right, why it's important to your business, and how to use and enforce it. So those I'd encourage you to do. We also have guides that are geared towards startups in general, as well as franchising, if it's something that you might be interested in your business. There's also another tool on our website on successful technology licensing that might be very useful for this group. It's a pretty good manual on how to structure agreements and why the various clauses work the way they do. So I highly recommend taking a look at that as well. Another tool we have is called IP Diagnostics, and that tool is to help you do a self-assessment for what you would need from an IP perspective in your business. So it asks you a bunch of questions about your business, and it gives you customized information about what kind of actions you might want to take to put yourself in a better position from an IP strategy standpoint and then for your total business strategy. So I'll point those out. We have another tool coming out very shortly called IP Business Moments, which gives you advice depending on the stage your company is. So it looks different if you are at the very beginning of your life cycle as a company than, for example, at the end towards acquisition or exit or partnership and investors. So walks you through the key IP issues from that regard. And then I'll mention one thing. I understand that this group is located in Kenya. So one of the programs that we have at WIPO is called the Inventor Assistance Program. And what it does is it helps businesses and inventors get professional support through the patent system at no charge. And that program, I'm happy to say, is going to be launched in Kenya later this year. through the local IP office. And I would highly encourage you when it comes out to consider, if you have inventions that you've thought about that need protection, to be able to go through the program. And the great thing about the program is it will help you both get support in Kenya, but also to globalize your portfolio in other markets, in several other markets. So those are just sort of an overview of what we have. Jen, I'll send you the slide, and my apologies for the technology problems. Happy to answer any questions if it would be useful. And otherwise, wish you the most success on your IP journey.
Great, thank you. I think what we'll do is we'll pull together a list of the program names, links, and other information and circulate that to the participants so they've got it at their fingertips and they can follow up on that. Is it okay if we include your email too?
Absolutely.
Okay, good. That's perfect. So going back to you, Mark, we've got a couple of questions in the chat that I'm seeing. So here's one interesting one. Can a nonprofit file for a patent or a trademark?
Excuse me, I was muted. It's always going to happen on one of these. So yes, nonprofits can. Typically in the world of trademarks, we take the idea of using the trademark in quote unquote business very broadly, or in commerce. And in fact, I work for a nonprofit. My university is a nonprofit. Universities in America get patents all the time, for example, because we have researchers here. I'm here in Akron, which was the birthplace of the rubber industry, and we have the world's leading polymer program at my university. So we're always, my university is one of the top 50 in the world in getting patents. So yeah, patents are really important. And so are sometimes trademarks. We have our mascot at the University of Akron is this little kangaroo, and we've trademarked the kangaroo symbol. And so yes, you can trademark your particular brands for your nonprofit, and certainly get patents if you're doing important research that's worth patenting. So.
Okay, I'm going to race you through. We have more questions.
Sure, this is great.
So if I'm designing a device that combines the functionality of multiple devices into one device, would this still be considered novel? And is it worth seeking IP protection? This is really an innovation, not an invention.
Maybe. The devil is in the details on that question. It's a classic actually patent law problem. So that takes assessment. Sometimes have people thought to combine these before? Was it obvious to combine these things, or maybe not? Or maybe you've combined them in a unique way, or you've had to solve a problem nobody else could solve in order to combine them. So it's really going to come down to the details, but it's possible. It's, the situation itself is not one that says no, yes or no to patenting. It's one that requires careful consideration, probably by an expert attorney. Yeah.
There's a follow-on question, another good question. Can you obtain IP for a specific feature of a device instead of the entire device?
Absolutely, right? So I keep holding up my phone, but Apple came out with this new combination camera a few product versions back, and I'm sure there are many patents combining the way these lenses work together. That's a feature, right? It's not just the product itself. And that typically nowadays, think about automobiles, right? They've been around for 120 years. And it's been a long time since the automobile was something we call an invention, but every few years there's something really new about your car. You open the hood, when I was a kid, that engine looked a lot different from the way it looks today. So yeah, there's constantly invention and new features being added to products that are patentable.
So we've got another question here in the chat. These are really all great questions. Thank you very much to the participants. How does an IP right registered in the US or the EU be utilized by a company operating in Africa?
It would be if you're trying to, stop people from copying you in that market, or two, if you want to sell into that market. And so, I've seen the instance of entrepreneurs who said, my own market's not very mature, and I may or may not need to file these IP rights in my market, but I have a potential multi-million-dollar market in the United States. And it's not as, sometimes that may seem like very far and out of reach to somebody in an emerging economy. But what we've seen is some of the most successful smaller economies like Singapore and Taiwan and South Korea is a medium-sized economy, but they got big, successful, and wealthy by targeting the bigger markets. So, entrepreneurs in Singapore, that's a city-state, but they file patents in the US and the EU, and they sell their products there. That's where their most important market is. Selling to the several million people in Singapore, however wealthy they are, is not their goal. Their goal is selling to the billion people, the nearly billion people in Europe and the United States and other wealthy markets that they've got patents in. So I think that's the kind of strategic thinking you're doing. Now, maybe if your product is, say, a soft drink that has a very local appeal, you're not as worried about that foreign market, or maybe at least not at first. But if, say it's a medical device, maybe some of the medical devices I've seen coming out of developing countries, you kind of make a virtue out of necessity. When people in the United States, doing an eye exam requires very large, bulky equipment in an office. And I've seen these Kenyan entrepreneurs created an attachment to the iPhone. People in the US don't think to solve that problem, but sometimes entrepreneurs in emerging economies think to solve these problems in ways that then are very exciting to people in these bigger economies. And that may be why we want to think of a patent or trademark in those bigger economies.
That's an interesting point. So I have one last question that I'll ask from the chat, but first I'm going to just give a quick pitch for my organization, which is Innovation Council. I mentioned what we do at the start, and we are always looking for new collaborators. So for new companies to join, tell their story. We do give visibility to the companies that work with us, connect them to other entrepreneurs and inventors. So if you're interested in joining, don't hesitate to reach out. Edwin knows where to find us. And we are thinking of putting together an offering of a couple of sessions with an IP mentor for some of the companies that are incubated by Villgro Africa. So if that's of interest also, please let Edwin know and we can connect that way. I'd like to, before thanking Mark, look at this last question that had been submitted. Question about the timing of filing the PCT application. You mentioned the PCT system. Do you wait until you're ready to, compete in all of the different markets that you might tick the box for in the application, or do you really file domestically in your own country until the moment when you're really ready to follow through on that PCT application?
So the virtue of the PCT application is that there is a grace period where you don't have to pursue those national applications, and experienced companies make use of that grace period. So what the PCT filing gets you is it gets you into the system, it gets you what we call a priority date, and then you can pursue your application 18 months later, but you have a while to decide whether you want to essentially begin the national prosecution phase, if we use the technical jargon. So no, the PCT is a very useful tool in that way, because you don't have to spend the money in working on your patent in the national offices immediately. You do have time to decide, but you preserve your opportunity to file, and you have this priority date that's established by the PCT filing. So the PCT is a really useful tool for building an international patent portfolio, and it gives you time to decide where to pursue the patent, or whether to pursue the patent.
Allison wants to chime in really quickly with a word on discounts for the PCT.
Thanks, Jen. I just want to mention that both the PCT and a lot of national offices these days have discounts that are either to individual inventors or small businesses. And people aren't always aware of these, and it can really have a significant impact. You know, some discounts are 90% on the cost of filing. So I just filing in some of the different various registration systems.
Thanks for that. Okay, well, we've got 1 minute left. I'm going to hand back over to Wilfred and Edwin. Thank you so much for joining. I hope it was useful. And again, be in touch if we can do anything more. We'll circulate more information from Mark and Allison. And back to Villgro Africa.
Thank you, Jen. Thank you, Mark. Thank you, Allison. This was really, really informative for all of us. I'm sure we've walked away with something. Just before I let Wilfred speak, I wanted to let you all know we'll have another session coming up on 3rd March that will focus on a more regional perspective of IP and how to file IP within your various countries. Jen, we have a lot of participants here who are from various countries, Ethiopia, I see Uganda, and Kenya. So yeah, you should all, you know, intend to attend. So yeah, let me hand it over to Wilfred to just close it off.
Thanks, Edwin. That was a wonderful session. Mark, Jennifer, you did a good, amazing job. And I will ask us to put at least an emoji on the chat to appreciate them. You can clap on the, Edwin, where is the clap button? Near the,
I think it's on reactions.
Yes, go there under reactions and let's appreciate them for the wonderful job well done. We'll be sharing the resources, including the video and the other links and resources that have been mentioned, and also follow up with you on the mentorship aspect that Jennifer spoke about. So I believe this is a first of many other similar interactions. And thank you all for your active participation. And we look forward to staying in touch.
Bye,
Thank you. Have a great day.
Thank you. Farewell.
Thanks for the emojis.
Thank you.